Can you talk about, or can you just kind of give some comments on why those third-party sites are just a no-go?
So there's a couple of reasons there. So number one, some of those sites pitch themselves as an alternative to a registration. So like you don't
Mm-hmm.
need to register with the Copyright Office because they'll charge you per application and per work, and it's so needlessly expensive. Why do that? Sign up with us. It's garbage. That's snake oil because in order to ever protect your work, and if you ever have to file suit for infringement, and if you ever want to get your attorney's fees reimbursed for that suit, the only way to do that is through the United States Copyright Office. There is no substitute. There is no way around it.
We are live. Thanks for joining us and for being here this week on the Vana Room. We have a very special guest, our first guest, actually, Davey Jay, who is an entertainment lawyer in Orlando, Florida, and Monique,
Hello.
who is the co-host with me. I'm very excited for this episode. We're going to be diving into all things kind of legal, copyrights, trademarks, all that stuff, kind of reaffirming and reiterating what Monique and I have been discussing over the past few months, I guess now. And Davey is here to confirm all that and really kind of dive in and why this stuff is so important. So how was everybody's weekends, or how's
Doing
everybody's
great,
weeks? Are we ready
thank
for the
you.
weekend?
So waiting for the weekend.
Yes, of course. We always do. It's like we always look forward to the weekends. So Davey, I want to kick it right over to you. If you would just want to give like a brief 30-second to a minute kind of intro
Sure.
on who you are. I know you do a lot of these talks, so I don't want you to
Yeah, no,
reiterate
I do
everything.
talk a lot. So yeah, anyways, I'm an entertainment and intellectual property attorney in Orlando. I'm at Meehle Jay. And practicing entertainment law has been my primary practice area for my entire legal career. So 16 years now. I have served as the chair of the entertainment law section of the Florida Bar. I'm a member of the Recording Academy and also of Women in Film and Television. And I've taught for more years than I can even remember at the undergraduate and graduate level, and also as an adjunct professor of law.
Great.
Nice.
Yeah. So Davey's just an all-around badass, and
That's pretty much what I call her.
Yeah, she really is, and I really look up to Davey and everything that she does. So Davey, thank you so much for being here.
Well, thank you. You know I adore you, Lennon. So anytime.
Oh, thank you. Thank you. And I know I've kicked over a few questions for you in the past, and I will work with you at some point. We will work together.
Absolutely.
So Monique, if you want to kick it off, I'll kick it over to you to maybe start the conversation.
Well, before we dive into, I guess, well, no, we'll go ahead and start here, and then I'll kind of ask this question, my main question at the end. So, obviously, we're talking to people who are aspiring musicians, already putting their music out, that sort of thing. And one of the questions that I get asked often is, when am I supposed to register my copyright? Do I register it before I send it to my aggregator? Do I do it after I send it to my aggregator? So in your opinion, or your experience, Davey, when is the best time to start submitting copyright registrations for your music?
Oh, you gave me a softball to begin with. This is a good one. So easing into today. Yeah, the answer is as soon as possible. You can register your copyrights before you release. So that's called an unpublished work at that point. So certainly you can do that. And the benefit of registering is as soon as possible is that there is like a golden period of time for registration, where if you register during this golden period of time, then you're entitled to get the full scope of potential damages if anybody infringes your work. So if somebody rips off your work, you're entitled to get not only the full statutory damages, but also to be reimbursed for or be awarded your attorney's fees and court costs if you wind up in litigation, which is huge. Like I am saying the fees can be huge. So that's a big deal. So you want to make sure that you have that full scope of remedies, because if you register later, certainly that's still good. But you might not be entitled to that benefit, which means filing suit to enforce your rights, it might be more expensive to sue than you would be awarded. So you want to try and register either before you publish the work or within 3 months after you've published. And again, certainly if you haven't done so, you published something a couple of years ago, it's still a good idea to register now, because the registration is what allows you to enforce. It doesn't give you your rights. You have your rights automatically, but registration is what makes it possible for you to enforce your rights. So you always do want to do that as soon as you can.
And I also want to, you said as soon as possible. I think one of the because I've seen, as you can attest to, there's so much misinformation out there about copyright registrations. And to your point about registering right away, I think it's important to point out that you should not be registering partial works. Like if the work is not finished, don't go, oh, I'm about halfway done. I should go ahead and register this just to protect what I have, or I should protect this. Can you speak on that a little bit about what should actually, when you say as soon as you can, you do mean a completed work?
Yeah, so generally a completed work. There are situations where an incomplete work, it might be wise to register it. So, like if you've got something that you're, just shopping the instrumental and you're looking for somebody to do vocals over it, then it might be a good idea to register the instrumental on a standalone basis. Because that's something that you're sharing with people at that point. So in that case, I would say probably the registration then, and then also a subsequent registration that encompasses the newly added parts later.
Mm-hmm.
So that's what I would say. And there's also for larger works, such as film, there's a pre-registration option because, like, with film, it takes forever. It's not the same
Mm-hmm.
as a song. So you're talking months and months of, pre-production, production, and post. So sometimes
Mm-hmm.
that pre-registration option is a good idea for a really massive project like that.
Mm-hmm. Okay. And so the types of registrations used for music are the works of performing arts, and the sound recording. Those are the two key registrations that are associated with music. And there have been some updates, if you will, to the types of registrations that can be done for sound recordings or albums. I'll specify albums because that's really what it's about, or a collection of work. So they now have the Graham application and the GRUW registration for a musical work.
Mhm.
And I think it's important, as best as we can, to explain to people how to utilize these two types of registrations, because I think even though the Copyright Office has done a great job of putting tutorials out and videos, I think there's still some confusion about what I'm actually registering. So, for example, if I, Monique, am releasing an EP of 8 tracks, and it's all recorded, I have my album cover artwork, which registration do I select for that? And I already know, I know that facial expression.
Davey's thinking like, oh, the Copyright Office has done a good job with releasing content.
Well, their website is better than it has been. I have to say,
That's true.
compare them to the trademark office too. I think they've done a much better job
Yeah.
of trying to educate people. I didn't say it was perfect.
Yeah. No, and yeah, the Copyright Office, their game's on point lately as far as actually processing too. Like they're going through registrations really quickly.
Oh, nice.
Like I've been looking at things
Nice.
like came back in like within 3 months.
Wow.
Wow.
Okay.
I know. Whereas
That's
Trademark Office, they're not even looking at applications until like 9-10 months later, which
Mm,
means it's taken over
Wow.
a year at least.
mm,
So it's
right.
so don't even get me started on them. But I think that's actually a good teaching moment to understand that trademark and copyright are so very, very different things.
Mhm.
So they're not interchangeable. So we're talking about copyright. So we'll stick on that. So to answer your question, which I blew right by, the answer is usually it depends. Because that's the face I was making, like, well, well,
I
So,
know.
yeah, I know yeah. So one of the things is that these group work registrations do have certain requirements that you have to check the box on all of these requirements in order to be eligible for this type of group work registration. And so one of the things is that each individual track, if we're talking about it like an album or an EP, whatever, each track
Mhm.
has the same information as far as who the author is and who the claimant, and the claimant means owner. So, who those parties are. So, like, if Monique and I recorded an album together, and all of them say that the authors were Monique and I, and all of them say that the claimant was both Monique and I, then that's no problem because the information matches from track 1 to track 8 and track 5 and everything in between. But, if there's one where, let's say, I didn't perform on one of the songs and you had somebody else, say Lennon comes in and he's featured and you're going to share the rights with him instead of with me, now those things don't all line up. Now that information is not all the same. And so in that instance, you wouldn't be eligible for the group registration because the copyright information is different for one of those tracks. So that's really kind of the main issue that you've got with the group registration, is that you want to make sure that it actually qualifies, because copyright.
Even
Oh, go ahead.
I'm sorry. I was going to say, even if the album was mine, so let's say it's my album and I'm the primary, I'm the main artist, right? And one song has you as a featured artist, and then not a featured artist, but like we did a duet. And then another song has Lennon. Even though you guys are on my recordings, it's my album. So because I am the claimant for the album, can I still register those recordings?
If you're the claimant for everything, yes.
Okay.
Yeah.
All right, just making sure that was okay.
Yeah, no, because if you've got a situation where you've got like variations in the claimants, you might have a problem there.
Right. Okay,
Yeah.
that makes sense.
I was just presuming in my hypothetical that we were all sharing nicely, which is usually.
Yeah, and honestly, we do have an episode where, and we'll have to bring you back for this, where we start, where we talk about the split sheets and, who did what, and so I can bring this up now since we're talking about it. What if I license a beat? So a lot of people get beats from another source. They either get it off of YouTube or one of these sites where somebody gave them I'm about to make Davey pull her hair out, a lease for a beat. Oh, people have no idea how that word lease just makes attorneys cringe.
Not on a Friday, Monique. That's a Monday question.
So
after this,
if right, I owe Davey a bottle. So if I license a beat from somewhere, does that change things?
I mean, possibly, but it always going to depend on the terms of that agreement for that license, or if we really need to call it a lease, we can say the word. But so it's first and foremost going to depend on that. But what that's going to change in your application and your registration is going to be that you're now going to have to disclaim part of it, most likely, because a license or a lease, it means a permission. It doesn't mean you're buying it entirely. It's like the difference between buying a car and renting a car. You rent a car, it's not yours, right? You just get the chance to use it for a while. Same thing when you license, a track, a beat, whatever. You're just getting permission to use it. You don't own it at this point. And so when you file your copyright registrations, there is a section, I think it's section 4, where it's like, are there any pre-existing works in here? So these are parts where you have to disclaim and say, yeah, this part's not mine. So you would say in that part of the application that there are parts that are not yours that belong to somebody else.
Okay. And then with the composition, so I know, and you can tell me if I'm wrong in my understanding. So the way I saw this new application working is, I could file a collect for my collection of my work, my EP. I can file a gram for that, right? But then for the compositions within those recordings, I have to file something different, because that registration is not protecting those compositions as well, correct?
Correct. Yeah, no, the
Okay.
Gram application is for the sound recording.
Just
Um,
the recording.
yeah, so and it's not
Mhm.
for, like, music videos or anything like that. So it's really
Mhm.
just for sound recording alone.
Mhm. Okay.
Mm.
And then another error I see a lot of people making, or students, when because I have an assignment where I make them do this. One of the errors that I'm consistently seeing, and I honestly think it's just a lazy thing. I see um, people trying to use the TX or the literary works registration for their song lyrics. Can you talk about why that isn't going to protect your work as a song, and what that, like, what are, if you can think of an example to explain like why you really should be registering your lyrics as a work of performing arts?
Um, well, I mean, generally it's just a miscategorization. And if you have any melodic element to your lyrics, then certainly you'd want to include the melodic element in the protection. And so if you're registering it as a literary work that by definition does not have a melodic element, it's just words.
Hmm.
So in the interest of protecting it in its entirety, that's, like you want to make sure that you file the right kind of application. Now, would this necessarily defeat the protections you have? Possibly not. It's kind of hard to say. Some judges are pretty, strict and by the book, and this is an improper registration. You didn't do. I mean, we have all sorts of case law on people arguing about these technicalities in these
Hmm.
registrations. Because what will happen is a defendant wants to try and kick out that registration and be like, nope, not validly registered, and so therefore, I win because you can't sue on an unregistered work and sort of thing. So that's,
Hmm.
a defense that we see often is that the registration wasn't properly done. Now, whether or not that's going to
Mm.
fly is going to depend on the facts of the situation and also really just the judge that you have. Again, some of them are real sticklers, and others are like, "Well, I think we all know what was meant here." Which is
Hmm.
really
Yeah.
frustrating.
So what you're saying is I could actually register a song under the TX. Not the best idea based on what I'm actually what I'm actually creating,
Right.
but you're saying it really depends on who oversees the case if it becomes an issue.
Yeah, and I mean, truth be told, like, are lyrics really any different aside from if we take away the melodic element? Are lyrics really any different than a poem or spoken word? Not really, so, like,
Hmm.
it's the wording that's protected in that situation, in that scenario.
Hmm.
So, and the other thing that comes into play is, when we look at comparing 2 works for infringement purposes, our threshold for what is infringement is substantial similarity. Are these 2 works substantially similar? So, certainly 2 musical works are often more similar than a literary work and a musical work, even though there can be substantial similarity between the 2. So, you don't wanna, necessarily distance yourself from what it really is,
Hmm.
artificially distance yourself from the true character of your work.
Mm.
Um, I know we're focusing a lot on the registrations, but I do want to throw this out there because this comes up a lot. Interpolations. Can you, as best as you um, can you talk about interpolations? Are they legal? Are they illegal? Like, what's the rule? I honestly I try to stay away from it when I teach class because to me oh my goodness, it can just there can be some gray area there. So I want to hear your thoughts on interpolations.
Well, I mean, there's always gray area in copyright, so, like, that's
Yeah. Yeah.
um, it's gonna be a very case by case situation because, like, when we're talking about interpolations, what people sometimes call it is flipping a song. It's taking something that
Mm.
exists and modifying it in such a way that it's different, but maybe not unrecognizable. So you might still be able to recognize the original, or you might just kind of be similar enough that you're kind of like, um, hearkening to it, but it doesn't rise to the level of infringement. You know what I mean? So, like, there can be a whole spectrum of what an interpolation is.
Hmm.
So, generally, what you want to do is steer clear from anything that you're doing that would infringe somebody else's copyright unless you're getting a license. If you're getting permission to do that, then hey, that's great. Fantastic. You got permission. It's all good to go. But if you don't have that permission and you're taking from another work and incorporating it into yours, you are leaving yourself open for a lawsuit, basically. Because one of the truest things I've found in doing this for so long is that when somebody takes another work, they don't tend to see it as a big deal or a big taking. But when somebody's work is taken, that's huge affront. Like, you took my work. Like, so people always underestimate how anyone else is going to view this. And they're like, oh, it's not a big deal. You know, it's just a little bit. You know, I only took a few bars of their music. And I'm like, how'd you feel if I took a few bars of your music and didn't credit you or give you any money and I got huge off of it? Like, you might not be okay with that, you know? So that's always something to kind of keep in mind as well. So interpolation can definitely be a very scary path to go down if it's not properly cleared.
A lot of, oh, sorry, go ahead, Lennon.
Oh, I was just going to say, Davey, I always use your car reference. Like, if you rented a car or used somebody's car and you painted it blue and you changed the wheels, it's still not your car.
Yeah.
It's somebody else's car. And I think that's such a perfect perspective things. If you think of copyrights and songs and other people's works like that, it's like, oh, I get it now. You're right.
Yeah, sometimes you gotta the Davey is the best with the ananalyes. Let me just tell you.
Oh, I love that analogy. I
She's
use
the
it all the time.
best, and I always
use it
have to
all the
give her
time.
credit when I steal one from her. Just letting you
I
know.
wouldn't want to steal anything from Davey.
Well, I don't know. At least I give her credit for it, right?
That's true. That's true.
One of the things that, or the two big genres I would say that Jamvana distributes are a lot of dance music tracks and hip hop. And within those genres, we have two potential issues that come up often. One is sampling, and another is remixes. So basically, if you're going to remix a song, what people need to understand is it's a new song. You're creating, even though you're using something that existed, it's now new. So one, you have to get permission. And then can we talk about what needs to be so let's say I did get permission, right? Do I need a new performing arts, a work of performing arts registration and a sound recording, or is it just a new sound recording?
Depends on the extent of your contribution to the new song. So, like, if your remix is really kind of a straightforward remix, like you are just messing with it, what exists, and not adding a lot of new stuff, maybe, but maybe not. It just depends on the extent of your contribution. That's always going to be the threshold for your new registration is like, have you added additional copyrightable material? You know, would this something on its own be copyrightable? Is this a copyrightable contribution to this work? If so, then this new work you've created, there is some part of that that's yours that you can lay claim to, presuming that in fact you cleared it. Because if it's not cleared, if you don't have permission for it, then you just submitted evidence of your infringement to the copyright office. You also committed fraud on the application because when you sign that you're attesting that you have the right to do this and all that other stuff. But, you know, all of that aside, it always is going to go to the level of your contribution and if that's sufficient to warrant copyright protection unto itself.
I want to get a little nitpicky here. When we say the word permissions, what does that look like? Is it just, hey, I send you a message on Instagram, can I use this track? And they say yes. What does getting permission mean? Like, what do I need to do to get permission?
Oh, that's a great question. So the thing is, you should have as much detail that anybody who is completely unfamiliar with you and the other party and what you're doing can look at it and understand the situation and what you're allowed to do and what you're not allowed to do. Okay. Because if you don't have that level of detail and the permission that's being given to you, I promise you, you're going to fight over it later.
Mhm.
because each one of you are going to have different notions of what permission means. So like if you're like, yeah, oh cool, I can, you reach out to somebody on Instagram and they're like, hey, can I use this? And they're like, yeah, cool, have at it. Did they mean that you could remix it? Did they mean that you could sell physical copies of it? Did they mean that you could license it for use in a film? Did they mean, you know what I mean? Like there's so many different ways to use something that, certainly you could run afoul of what their intent is and they could be like, hey, I didn't mean that. And now you've got a problem on your hands. So it's kind of like the thing where it's like if you ask, here we go with cars again. Cars are so easy to incorporate in this. If you ask them to borrow their car, right? So generally, the normal person would think this means like, oh, I need to run up to the store for a minute, or I'm going to go grab some food and I'll be back quickly. It doesn't mean, can I borrow your car to travel cross country with it?
Mhm.
It doesn't mean, can I borrow your car to take it out to, and the word has totally escaped me, but where they like the derbies where they smash cars up.
A demolition derby.
Demolition derby.
God,
Yeah.
words are hard after a long week. But yeah,
Yes.
did that permission to take their car mean you could take this car into a demolition derby? Hey, you gave
No.
me permission to use your car.
Mhm.
You know what I mean?
Right.
So
That's true.
yeah, so generally what you want to do is get enough specifics in this permission so that it's clear what you can and can't do, because if you don't have that clarity, then later you could have a problem as far as the other person arguing that you exceeded the scope of permission, and exceeding the scope of permission means you're infringing their copyright.
Right.
And is this permission, can this be done over an email, or does this have to be like some type of contract that's drafted and then signed?
Well, that's a could it or should it question. So could it?
Ah,
Yes. It could be done in an email. It could.
okay.
Used a lot of those as evidence before.
Yeah.
Um, you know, should it be in an email? Probably not, because usually a full contract is going to have a lot more detail in it, and it's going to have protections built into it that you're not going to get in an email. So, theoretically you could, but whether you can and whether you should are two different questions.
Correct.
Mm.
Mhm.
So I wanted, as you were discussing, and Monique brought up remixes. Um, there are a lot of, especially in the dance world, there are a lot of musicians and artists that do remix contests.
Mhm.
So a lot of people will download the stems and they'll sit on their computer for a year and they'll be like, "Oh, I love this song. I want to remix it." But those stems are, and the contest has ended, 9 months ago. What, in that case, when you have access to goods that maybe you shouldn't have access to anymore, is that, are there specific rights within the remix contest, or how do those work?
Well, you're generally going to want to look at whatever the rules are of the contest, because if it's a more formalized contest, they're going to have rules that are posted somewhere for you
Yeah.
to look at that are going to say, like, this is what you can do, this is what you can't do. And when the contest is over, so end any permissions granted here. Or that you can only remix it for the purpose of this contest. You can't release it otherwise, and that sort of thing. So generally, that's going to be your first step, is look at the rules and see what they say. If it's something that's a little more loosey goosey, which, it can be like, people be like, hey man, hey guys, I'm going to release my stems. Check it out. Remix it. Let's see who does the best. Like we'll do a little, mixed competition here. In that instance, we have to look at their intent. And so in granting that permission, the original owner didn't say anything that could clearly be interpreted that you could use this forever, or you could use this for different purposes. So if they're like, hey, I'm releasing the stems, we're going to do, remix contest, then it's pretty clear the purpose for which that release was given. You know what I mean? So it's, it would be hard to say, oh, well, I had a reasonable belief that I was allowed to do other stuff with it. Be like, based on what? The fact that it was accessible, like,
Yeah.
bread's on the shelf. You could grab it and stick it under your shirt. Doesn't mean it's not theft, like, so it's the same kind of idea.
Yeah. Okay. I've seen a lot of dance artists go on Twitter and they're like, "Hey, I'm doing a remix contest. Here's a Dropbox link to all the stems. I'll be reviewing submissions next month live on Twitch."
Yeah.
And it's more, I feel like, an engagement. They're trying to just
Oh,
engage
absolutely.
their producer communities. But there's also, we got to remember that this isn't, your song, or
Yeah,
you're just given permissions within a specific period of time.
exactly.
And we talked about remixes. I want to throw samples in there now, but the one thing that I think is important for people to understand. So Lennon's question was about what does permissions look like, and you explain what's the scope of your what you're allowed to do. I think what's important to also bring up, and Davey, you can really shed some light on this, is the first thing you have to understand if you're going to do a remix or sample is that you don't just contact the record label, you also are messing with the composition, which means you also have to contact the owner of the musical work or the work of performing arts copyright registration. So in some cases, it can be kind of easy to find out who owns the musical work. You can look on a PRO site. Finding a publisher is kind of easy in most situations.
Mhm.
What about the sound recording, Davey? Like, it is so, I find it very challenging. Can you shed some light on finding out who owns a sound recording?
It can be really hard. It can be incredibly hard. I straight up go Google Ninja on that stuff. Um, and I go down some very dark and strange rabbit holes sometimes looking for rights owners. And that's,
Mhm.
Unfortunately what I have to do on occasion, because I'll have a client be like, hey, I've been looking for, trying to find these rights holders so that I can license this stuff. Can you help? And I'm like, well, I can sure try. And so I've made
Mm-hmm.
more headway just because I'm used to kind of looking in certain places and finding, oh, well, maybe I'll search up the name of, first when you do like a regular, Google search on it, if the copyright office is not giving you any help.
Mm-hmm.
Let's say you want to remix something that's, an English artist. They don't have a registration procedure in England. In the UK, it's not there, so there's no copyright office to look up. So then what do? Well, then you can start just doing a really deep dive on the internet and see what you can find. Sometimes that means looking up people who are affiliated with the project and kind of see where that leads and that sort of thing. Sometimes trying to find out who, if everything else is coming up empty, maybe look at who, if that artist has a manager, and reaching out to the artist manager and saying like, hey, trying to license this, can you give me some insight on who I contact for, clearance on this, because I'm just hitting a bunch of dead ends here. So sometimes that's helpful. And the sad thing is, like, even if you go through all of that and you find out, oh, aha, it's universal, like, yeah, all right, then you can be in a position where you're submitting a request and then following up and following up and up, for like weeks and weeks and even sometimes months before you get a response from them.
Yeah.
And that's very disheartening to people sometimes too, that, the whole licensing process, it's not easy even when you find out who you're looking for as far as the rights holder goes. They get inundated with requests. And so it takes them a long time to get back to everyone. And it's very frustrating. And I'm sitting here like, my client just wants to give you money. Like, why don't you
Right.
want my client's money?
Yeah,
Can you please
true.
take money?
I like
So it's
I like
frustrating.
Oh, yeah, I like all that information, but I've also found, like, going to Spotify, and you can see, like, copyright under the song. It says
Mhm.
copyright 2022, Dim Mak Records or Sony
Mhm.
Music Group,
Yeah.
and that's also a good start there. So it's like,
But
okay,
you
this
still
is
got to
most
find the
likely.
contact information.
Exactly.
That's the
Exactly.
challenge, is
And
you can find, I always say follow the money. So sometimes I'll do Spotify or I'll get on Amazon, and if I can find it on Amazon, the information, the metadata from the ISRC code will again tell you. And then here's something else to add to what Davey was saying about permissions is you need to make sure you're asking for permission for the right version of the song that you're using, because
Mhm.
you might be using a version of the song that was already remixed by somebody else,
Yeah.
and
Yeah.
so it just, oh my god, it's such a headache. Like, I can't imagine what you go through as an attorney trying to help your clients with this. I mean, I tried to help a student find a song, and we can't find the recording or who owns that recording anywhere?
Yeah.
You know? So that brings me to another question for you about old songs or abandoned works. What constitutes an abandoned work?
Oh, you mean like an orphaned work?
Is that okay? Is that the correct term? Orphaned? Okay.
So basically an orphan work is one in which we can't find its parents. We don't know who owns it. It's kind of been lost to history. We have no idea. There's this amazing work out there, and it's just like so sketchy as to who owns it. And this happens a lot with like older works, because like the company that released it or had the rights initially, you know, like the label perhaps, got bought out by another label, which went bankrupt, and they had an auction for their assets. And then somebody in the auction bought some of the rights and somebody else bought other rights. So it wasn't like a consolidated transfer of all of the rights to one organization. And then that merged with somebody else. And then it restructured and renamed itself. And this is why we drink.
Good Lord.
Yeah, so it can be, you know, sometimes the trail just runs cold. Like you have no idea who owns at that point. And that can also be the case when like an individual owner passes away and there's no will. And then there's like, okay, well, did we even probate the estate? Sometimes they don't probate the estate, which means go through and like inventory and make sure that all of the debts and assets are settled and everything's been given to the heirs and whatnot. So sometimes that's not done properly, especially in older cases. So yeah, at that point, we're just like, we have no idea who owns this. So an orphaned work doesn't necessarily, by virtue of the fact of it being orphaned, impact its copyright status per se. You don't like lose your copyright just because you can't find the owner. And in part from a policy perspective, that's because everybody be like, oh, gee, I looked real hard and I couldn't find it. And I guess I can use it. You know what I mean? Like
that's actually going to be my next question. Like, what evidence should I have to show that I actually did my search legally?
Yeah,
to cover my butt.
I don't know how much that's going to cover your butt, though. I mean, like it might minimize. Like if an owner popped up later, right? And they're like, hey, that's my work. And you're like, dude, I've been looking for you for like 2 years. And they're like, well, don't care. You found me now. And that's infringement. So the fact that you made a good faith search certainly comes into play as far as minimizing any damages that you would be liable for. Because it wasn't really at that point, I mean, it was still technically willful if you knew it was protected. So it does wind up minimizing your damages, but it doesn't change the fact that it was still protected.
So best practice would be if you are using something and you did your due diligence, you really sincerely cannot find the owner of that work. How much should I set aside for them then in the event they show up out of nowhere? Like, do I just have to give them half?
Well, I mean, it depends, but are we going worst case scenario here?
I guess. Okay, let's go worst case scenario.
Well, you know I'm disaster girl. That's what I'm always talking about.
Yes, I love the disasters.
Yeah. So, worst case scenario, they file suit against you right out the gate. There's no requirement that they send you a demand letter. I've had clients who that has happened to. They didn't know they were infringing somebody's copyright and just got straight up served with a federal lawsuit.
Wow.
That'll ruin your day.
Another reason to drink.
Yeah, absolutely. I can come up with plenty.
Drink. This is a good game. This is a good drinking game for the next IP seminar or something,
yes,
Davey.
We need to do that. All right, let's make that happen. All right,
Situations that make you drink.
Client gets sued right out the gate. They have to hire an attorney. Let's say the copyright owner is not willing to settle because they're just, mad as hell and they want to punish you and they have a war chest so they can fund this litigation. You're looking at 2 to 3 years in federal court. Your attorney's fees alone are going to be well over $100,000 over the course of those couple of years to defend yourself. Yeah. And then let's say you lose. You could then be on the hook for the other person's attorney's fees if they had registered timely. So, that would be all of your legal fees plus all of their legal fees, and then whatever damages were awarded.
So wait, you're saying that even though I did my due diligence and sincerely made maybe a year and a half, 2 years effort trying to find this person, no can do, I put this song out, I'm making money, they find out I'm using it, they can file a registration? Is that what you're saying when you said registration?
It was already registered.
Oh, okay. I thought you were saying like they registered something after the fact.
No. If they registered after the fact, then they would not be entitled to fees and costs.
Okay.
In most cases, as long as it's been longer than 3 months from the date they released it, yeah. So, and in this hypothetical, it's an older work, and you weren't able to find the owner and that sort of thing. So, yeah.
So talking about searches, like the three of us have all mentioned different ways to search: the Copyright Office, Google, Spotify, Amazon. The Copyright Office search database is a nightmare.
Indeed.
Do you have any recommendation on the best way to search for something when you are trying to do a search through the website?
I mean, there are options available, but they're expensive. Like if it's a desperately like we need to find this, like matter of life or death kind of situation, you're on a big budget project, and like you're the music supervisor for like this major motion picture, and the director's like, I need this song and I need it, and I will take nothing else but this song, and you've got to find out who owns it. Not only can you pay the Copyright Office to do a physical search, which they charge hourly for, to go through their records and stuff like that. You can also, there are companies that offer copyright search reports and whole chain of title reports on copyrights. They're not guaranteed to give you the results that you're looking for, but they are available, so that you can, order a search report for one of them. So those search reports, depending on what you're looking for and how old it is and that sort of stuff, you're looking at somewhere between like, just for the report itself, probably between like $400 and $800 just for the report. And like, that's why I said, like, if you're working on a major, big budget tentpole major picture, like they're not going to blanket $400 to $800 for a report fee. So that's an option too. So there are ways to do like, really deep research on this kind of stuff, but it's still not guaranteed to necessarily find what you're looking for. But yeah.
Is it necessary to hire a attorney to help me file a copyright registration, or is that something one can do themselves?
Usually somebody can do it themselves. The clients for whom I file registrations for copyright, it's either somebody who's got more money than time, because they're like, I know I probably could figure this out or I could do this myself, but I just don't want to. Okay, no problem. Or somebody who would just prefer to leave everything that's done is done in the hands of a professional. You know what I mean? So in that instance, yep, happy to help. Here I am. But the majority of my clients prefer to do it themselves. I always advise them that if you're going to do it yourself, I don't object to that. I will if it's a trademark. I will tell you that is a bad idea and it's going to cost you more money for me to fix it later. And there's a really, really high chance I'm going to have to fix it. But with the copyright, most people can navigate that themselves so long as they take the time to go through the tutorials that the Copyright Office has. And I also warn them that, when you're signing up to file registrations through the Copyright Office, that, number one, don't lose your password because you can't get another one. There is no password recovery in the Copyright Office. So write it down. And number two, be prepared to hop into your little time machine and go back to like 1994 when you get into what they call ECO, Electronic Copyright Office, because that side of their website is horrific. You know this, Monique. Like,
Yes.
I always tell, especially my clients of a certain age, I tell them, I'm like, whenever I open up the ECO, I kind of feel like my dot matrix printer should be warming up in the background. Because it's not super user friendly as far as the interface goes.
Right.
But it's totally doable, especially if you use the tutorial. And then certainly if you have questions, the circulars are fantastic and they're written in plain, normal people English. It's not like I'm asking you to go read the federal statutes. The circulars are written in very, straightforward. Hey, and here's an example. If X and Y, then Z. And you're like, oh, okay, cool. X and Y, then Z, kind of a thing. So those are usually quite straightforward. So yeah.
And as a tag on to that question, there are a lot of third-party websites out there that there are a ton of third-party websites out there that are just, they burn my gut when I see them. And these are sites that are like, hey, register your copyright with us for $99 plus the government filing fee, or $49 plus the
they're running BOGOs on copyright registration.
Yeah. Can you talk about, or can you just kind of give some comments on why those third-party sites are just a no-go?
So there's a couple of reasons there. So number one, some of those sites pitch themselves as an alternative to a registration. So like you don't need to register with the Copyright Office because they'll charge you per application and per work. And it's so needlessly expensive. Why do that? Sign up with us. It's garbage. That's snake oil, because in order to ever protect your work, and if you ever have to file suit for infringement, and if you ever want to get your attorney's fees reimbursed for that suit, the only way to do that is through the United States Copyright Office. There is no substitute. There is no way around it. Only one way to do it, right? So all of those sites are basically saying, we'll just keep a record that you sent it to us. If you want,
which is something you can do in Google Docs.
You can do it in Google Docs. You could email it to your mom. It's no different than emailing it to your mom and being like, hey, mom, check out what I made. And your mom is going to be like, oh my God, my child is the most brilliant ever. You know what I mean? So and it's free. And it's free. Like, your mom shouldn't be charging you to email her. So there's that. Other times, they might be saying like, oh, use our services for us to file your registration. And they actually do file it with the Copyright Office. The thing is, at that point, you need to be super careful, because those sites, by and large, I can't say everyone because I haven't read every single one. I haven't seen every single one. Every one I've encountered, and it's been quite a few, have all had these disclaimers in there that said, we're not your lawyers. We offer no warranties or representations about any of the information we provide to you or any of the information we submit on your behalf. So if they screw something up and it defeats your registration, you have no recourse. Meaning there's nothing you can do about it. You can't go after them for messing it up, because those were in the terms and you agreed to their terms when you signed up with their website. So it leaves you hanging, right? Like, so totally unnecessary. You're paying extra money for something you could do yourself, most likely, and not getting any guarantees with it. So it's just, there's not any upside I see to it at all.
Right. I mean, it's a mistake you can make on your own in the first place, less the extra $100 or $50 that you shelled out to make that mistake.
Right.
So yeah. Well, I know we have to let you go here. One last quick question. We're probably going to have to do a part 2 with Davey. Music videos. Which registration? Do you use the motion picture audio visual, or do you use a work of performing arts?
That's a motion picture. Yeah.
Motion picture for a music video?
Yeah.
Okay.
Is that, how is that different from a regular like sound recording?
Because the sound recording would be registered just as the SR as a sound recording. So if it's got no visual element, then it's just the SR for the sound recording or the performing arts work, the PA for the composition and lyrics. But if it's the video, then yeah.
Okay.
Mhm.
Interesting. Yeah, I think that would be a whole other question because everybody always discusses like the sound recording and getting the music register, but what about the social media, the pictures that you're taking for, hiring a photographer? Who owns those pictures? Can I
YouTube,
use them?
putting
What can
stuff
they
up
be
on
That is
used for?
YouTube.
such Oh my God. And I just, yeah, before we wrap it up, I just want to say it's so, so important. And so many people overlook this that anytime you've got somebody creating content for you, whether it's your logo, whether it's photographs, whether it's your music video, if you don't have them sign a contract that properly transfers the rights to you, you don't own the rights to that stuff, even though you paid them,
Mhm.
even though you told them, like, this is my concept, this is my idea, they're making it just for you. That doesn't matter. Like, legally, you don't own the rights in any of that stuff unless and until they sign something that transfers those copyrights over to you. And I've seen
Mhm.
so many people get in trouble with this, like where they thought they owned their logo. Why wouldn't you own your logo? Because they didn't sign a contract with the graphic designer, and then now they
Mhm.
don't own it. And that's crazy.
Mhm.
Mhm.
That's crazy, but it happens all the time. Same thing with, again, photography, anybody else, anything else that you're having content wise created for you, make sure
Mhm.
it's under contract so that the rights transfer to you.
And
Yes.
it would be similar. I'm thinking of, okay, going back to the car situation. I can give Davy $10,000 for her car, but if she doesn't give me the title with both of our signatures,
Yeah.
I don't own the car, even
Yeah.
though I paid you $10,000.
Right.
Mhm. The
So
understanding might have been there, but legally, you need to have
It didn't
that
transfer to you.
documentation.
Yeah.
Mhm.
didn't transfer it to
Yeah.
me. Nope. Nope.
Well, Davey, thank you so much. And of
Yes,
course,
thank you.
we're going to be bugging you again for, part 2 and part 3
Love
because there's just, and
it.
I'm sure we're going to have a ton of questions in the comment section to follow up with too. So definitely looking forward to our next conversation with Davey. So thank you so much, friend.
Thanks for having
Yes.
me.
Thank you, Davy.